Hello, and thanks for tuning in again. My name is Joel Herrera,
And I'm attorney Lorena Rubio.
and we are here to update you on our discussion of the recent changes to the laws here in Illinois as it pertains to workers and COVID-19. So last week we discussed a change in the law which came into play on April 16th. And we produced a video informing folks of what those changes meant. And to recap quickly, what those changes were intended to do and came into play was to protect frontline and essential workers. And the law stated that if an essential worker or a frontline worker contracted COVID-19, that it was presumed that it was contracted from their work. And so there was immediate response to this change and an immediate lawsuit. Shortly after the enactment of the law, there was a temporary restraining order entered, and earlier this week, on Monday, the law was repealed altogether. So today is now April 30th, and as it currently stands, the law is no longer in play. So we wanted to talk to you about what this means. So the question for today is, what does this now mean for our frontline and essential workers? Lorena, can you tell us a little bit about this?
Yes, so we still believe that frontline workers are going to get some sort of protection under workers' compensation law. So that means that for those people that are currently working out there as nurses, doctors, you're an essential worker, and you do contract COVID-19, then we are still going to be able to file something at the commission to get you some sort of benefits, and that we still believe that you are going to be protected. There is no longer that presumption that we had before with the amendment that was repealed. But in terms of benefits, we still think that we can find some sort of a strong correlation between your job duties and you contracting this disease.
And that's a very important point. So the only thing that's really changing now is that the presumption that you contracted the virus at work is no longer there. However, with the stay-at-home order in place and the nature of the job for essential and frontline workers, we still think that we would be able to prove that you contracted the virus at work. Now, these are going to be very fact-specific situations, so if you have any questions, please give us a call. The other question that comes into play is, so what does this mean if you're not an essential employee, if you're not a frontline worker? And Lorena, can you tell us a little bit about that?
Yeah, so if you're not a frontline worker, we are going to have a little bit of a harder time us showing that you contracted the disease at work, just because now we don't have, you might not have as much contact with people that have this disease. So in general, it's just going to be harder. As Joel's saying, this is going to be a case-by-case basis situation. So if you do get it, it doesn't mean that you don't get any benefits. It doesn't mean that we're just saying that workers' comp no longer applies to you. It just means that we might have to do a little bit of more work in terms of sparsing out these cases and figuring out what we can file and what we can't.
Absolutely. And the important thing here is to understand that things are very fluid these days. Things are, as we can see over the past 2 weeks, they're changing on a regular basis. So our goal here is to keep you informed of these changes, and we'll continue to do so. If you have any questions or concerns, feel free to reach us at 773-756-5151. Thank you.
Thank you.